Second reading.
Honourable Attorney General.
I move that the civil appeal, Mr. Deputy Speaker, sir, I'm sorry. I move that the civil appeal bill number 21 of 2025 be read a second time.
Seconded.
So, Deputy Speaker, sir, this bill forms part of our ongoing effort to modernize the justice system, to make our laws simpler, clearer, and more coherent. Following the Criminal Appeal and Criminal Review Act, which streamlined criminal procedures earlier this year, this bill now does the same for civil cases. The bill may look small if one stops at the number of pages it covers. However, a closer and more informed look at its provisions reveal that this bill is part of a bigger picture. It is part of the long and important process of rebuilding the system to make the processes simpler and less burdensome. We are still in the throes of addressing all the issues that need to be looked into to provide a better and more efficient system of justice. At present, Mr. Deputy Speaker, sir, the rules governing civil appeals are dispersed across several statutes, namely the Court of Civil Appeal Act, the Courts Act, and the District and Intermediate Courts Civil Jurisdiction Act, amongst others. Each has developed separately, resulting in inconsistencies, overlapping provisions, and uncertainty for litigants. The result has also been confusion, procedural disputes, and unnecessary delay. This bill remedies the situation. It consolidates all civil appeal procedures into one coherent framework, replacing outdated enactments and standardizing the rules that apply when an appeal is made. First, to the Court of Civil Appeal from a final decision of the Supreme Court in its original jurisdiction, or second, to the Supreme Court in its appellate jurisdiction from the final decision of a subordinate court, such as the District Court, the Intermediate Court, the Industrial Court, the Master and Registrar, the Judging Chambers, or the Statutory Tribunal. Henceforth, all such appeals will follow the same process from start to finish. Mr. Deputy Speaker, sir, let me briefly guide the House through the principal provisions of this bill. Clauses 6 and 13 provide for a uniform procedure for the lodging and prosecution of appeals. Whichever court the appeal lies to, the Court of Civil Appeal or the Supreme Court, the same steps, time limits, and forms will apply. Clauses 9 and 15 empower both the Court of Civil Appeal and the Supreme Court in its appellate jurisdiction to determine questions of law referred to them by subordinate courts. This will allow for timely clarification of legal points that would otherwise create uncertainty at lower levels. Clause 18, introducing more realistic time limits for the filing of skeleton arguments and submissions. Appellants will now have to file their written submissions 30 days before the hearing rather than 45 days, whilst respondents will file theirs 15 days before rather than 30. These adjustments reflect the experience of both practitioners and judges and will make scheduling and deliberation more efficient. Clauses 19 to 23 harmonize the powers of both appellate courts. Previously, the Court of Civil Appeal and the Supreme Court did not enjoy the same authority when determining civil appeals, a technical anomaly that this bill now removes. Clause 3 introduces a simple but important safeguard. Every court, immediately after giving judgment, must notify each party in writing of their right to appeal. This ensures that access to justice is not hindered by lack of information, especially for litigants without legal representation. Clause 29 provides for consequential amendments to 6 statutes: the Courts Act, the District and Intermediate Courts Civil Jurisdiction Act, the Environment and Land Use Appeal Tribunal Act, the Equal Opportunities Act, the Industrial Court Act, and the Sale of Immovable Property Act. The Court of Civil Appeal and its 1965 rules are repealed entirely, making this bill the sole reference for civil appeals. However, Mr. Deputy Speaker, sir, I will be proposing amendments at committee stage to this clause 29 of the bill, more specifically to amend the Court of Rodrigues Jurisdiction Act and the new Revenue Tribunal Act so as to align their procedures with this new legislation. Together, Mr. Deputy Speaker, these clauses establish a single, predictable system that applies uniformly across all levels of the judiciary. Civil appeals will henceforth be simpler, quicker, and less prone to procedural disputes. This will also reduce the burden on the courts by discouraging points of law being raised on unclear or overlapping provisions. The preparation of this bill, I must stress, Mr. Deputy Speaker, sir, has benefited from close consultation between my office, the Chief Justice, and the judges of the Supreme Court. It reflects their experience in the daily administration of appeals and their support for the creation of a unified and rational structure. This reform also sits within the wider context of judicial and legal reform already underway. In recent months, Parliament has enacted the Revenue Tribunal Act, the Legal Aid and Legal Assistance Act, and the Criminal Appeal and Review Act. Each of these bills now enacted have aimed at simplifying access to justice and restoring coherence to our legal framework. This civil appeal bill now furthers this goal for civil matters. The government is working to implement the various necessary changes for these different statutes just referred to, to all be proclaimed and enforced as from the 1st of January 2026. Again, proposing uniformity and clarity for all these changes. Mr. Deputy Speaker, sir, codification arises from the need to transform scattered, inconsistent rules into a single, rational body of law. From the Code Civil des Français of 1804 to the Field Code in the 19th century of America, codifiers sought not only to compile existing laws, but to impose coherence upon them, to replace fragmented statutes and judicial customs with a systematic and accessible structure. Historically, such efforts emerge when legal systems mature to a point where accumulation breeds confusion. The aim is twofold: compilation by gathering dispersed provisions into one reference text, and rationalization by simplifying, harmonizing, and removing contradictions. In modern procedural law, Mr. Deputy Speaker, sir, codification reflects the same spirit: efficiency through clarity. By standardizing appeal routes and timelines, a codified regime ensures equal treatment, predictability, and ease of application. Ce n'est donc pas juste pour faire joli, mais plutôt la poursuite d'un idéal issu du siècle des Lumières, que la loi soit claire, connue et compréhensible pour tous. In practice, Mr. Deputy Speaker, these are not abstract measures. They affect real cases, real people, and real time saved in the delivery of judgments. The ultimate aim is to make the law not only fair in principle, but clear and efficient in operation. This is thus a practical reform, the product of broad consultation, careful drafting, and will obviously strengthen the administration of justice, bring clarity to practitioners and litigants alike, and reinforce public confidence in our courts. Mr. Deputy Speaker, sir, I therefore commend this bill to the House.